Derek here of McKenzie Friend Consultants. Welcome back. I've previously posted a couple of videos on dealing with false allegations of domestic abuse against you. However, this issue has become so endemic in the family court that it needs a totally fresh approach. Now, just before we get into the video details, if you feel that this video is helpful, then hit the subscribe button below, as you'll probably find my other videos useful as well. I want to make a couple of disclaimers before we get into the details of this video. I'm not condoning domestic abuse in any way whatsoever, as domestic abuse is a serious matter and the perpetrators of these heinous crimes deserve severe punishment. However, I'm not addressing these real and very serious cases of domestic abuse in my video today. I'm addressing the other 90+% of cases with false allegations being raised daily in the family courts. They are typically raised by resident parents with a mission of revenge and hatred against their former partners and using allegations of abuse as a weapon to justify their decision to stop your contact with your children. Whilst there are some cases where the allegations are being made by the resident fathers, they are rare, and the vast majority of cases are from resident mothers wanting to make their ex's life miserable. So please forgive me if you are a mother that is suffering from the same plight, but in my video today I will be referring to the overwhelming cases of fathers being targeted by vindictive mothers. And the message and approach should be the same for you. As you have probably noticed from my previous videos, I totally support and promote reducing acrimony in conflict as the best way forward with your family court case. I still totally believe in this approach, and that should always be the first tried. But this approach is clearly not working in these cases with allegations of domestic abuse. The family courts are powerless to deal with these cases in a pragmatic, sensible way to nip this poison in the bud. The minute that abuse is raised, Kafkas and the courts panic. And unlike criminal courts, whereby the party is innocent until proven otherwise, the family courts in that system automatically treats the father as though he is guilty of abuse, even though the resident mother has failed to provide a single shred of evidence, apart from her false claims to the police, children's services, and anyone else that is prepared to listen to her. Kafkas and the mother's representative waves the practice direction 12J magic wand, and lo and behold, the magistrates and judges are paralysed with fear and make those immortal words. The court will need to consider practice direction 12J and the disputed allegations of domestic abuse and decide if a finding of fact hearing is deemed necessary. Now, unless the mother rescinds her allegations, the court will start the fact-finding hearing process. The fathers are then consigned to very limited contact with their children, either a couple of hours a fortnight in a contact centre, or even worse, half an hour FaceTime call once a week or two. The fact-finding process used to have a 6 to 9 month delay. However, due to the backlog, it now adds delays of 9 to 15 months in most cases. And during this time, you are not allowed any unsupervised contact with your children. You have not been found guilty of a single thing at this stage, but you are being punished as if you are an abusive monster. Your ex's wicked selfish agenda is now playing out very nicely in the family court. In my previous videos, I discussed hitting back with your own allegations of abuse. And this approach is having limited success, but it needs enhancing further now. In a recent case, the father raised his own allegations against the mother as per our strategy. But when the judge was considering the allegations raised by both parties, and if they were relevant for a fact-finding hearing, he asked the father if he is requesting a change of residency and the children being taken away from their mother. Now, as the father was a decent guy, he said that he wouldn't want to go that far for the sake of our children. The judge responded that in that case, you are not saying that your children are at risk, and as such, your allegations are not relevant in this case. The mother, of course, stuck by her position, but the children are unsafe in the father's care, and as such, the fact-finding hearing has been directed to hear her allegations only, with the father facing the court firing squad. So, what can we do? Unfortunately, it has got to the stage that the only possible way forward with these intolerable cases is to fight fire with fire. You have to mirror everything that this selfish resident mother does. If she submits a C1A form with allegation of abuse, so must you. If she applies for a non-molestation order, so must you. And if she is claiming that the children are unsafe in your care, so must you, and request a change of residency to you. It's a shame that it has come down to this, but I can see no other way, and rather than the father simply being lined up to be shot by the court, you need to level the playing field. If you have allegations of abuse levelled against you and want help with your case, then go to www.McKenzie Friend Consultants with an s.co.uk and book your free consultancy with me. That's it for today, and if you have found today's video helpful, then hit the subscribe button below, as you will probably find my other short videos useful as well. Bye for now, and until my next video.